Welcome to the O'Connor Elder Law channel. I'm your host, Melissa O'Connor. Today I wanted to address with you the establishment of probate attorneys' fees in the state of Florida. So many times I have people come into my office really concerned about how much will the attorney's fees be for the probate of their loved ones' estates, because they're really concerned whether they should just go it alone and do it themselves, or if they should hire an attorney, and how much will that cost. There's a lot of mystery when it comes to attorney's fees, and particularly in the probate arena. And that's because there's different ways different attorneys set their fees. Florida statutes that govern the probate of estates here does provide what we call a statutory fee, meaning attorneys could they could set their fee and take their fee pursuant to this statutory guidelines that's set forth by the legislature that essentially says that certain estates of certain amounts, the reasonable attorney's fees are X dollars, or a percentage of the estate. And so attorneys that work under the statutory scheme would be able to collect their attorney's fees at the end of the case based on a percentage of whatever probate assets were in the case. So depending on the size of probate assets, that means then that's the size of the attorney's fees. Some people don't think that that is really the best mechanism, and many times that the statutory fee is more expensive than had the family had entered into an agreement with the attorney to do the work on an hourly basis, because even though the probate assets are greater than another case, the amount of work, generally speaking, it's not always, if there is litigation involved, it could go increase greatly. But generally speaking, if this is a happy probate, if there is such a thing, a pain-free probate, one where the family simply wants to pay the creditors and disperse the assets pursuant to the will or the law and not argue about it, just the goal is to move the assets and make sure that the affairs of their loved one is wrapped up. The amount of work is about the same, no matter if the estate has a lot of assets or not so many assets. There's still the same notice to creditors. There's still the same obligations that the personal representative has to go through. So some families find that the statutory fee just wouldn't be best for them, because they might be better off with a reasonable hourly rate for an experienced probate attorney that can smoothly do the work, and the amount of time expended would be less than the statutory rate. Another mechanism that families may or personal representatives may wish to look at is a flat fee. Many probate attorneys in the state of Florida are willing to probate estates for a flat fee, where that's negotiated up front. You're very clear as to what the arrangement will be. You know what the price is. There is a scope of work, which means that there might be triggers saying this is a flat fee for an uncontested probate, but should somebody wish to litigate the matter, then the rate would be either at the hourly rate or transition to the statutory fee or something of that nature. But many times a flat fee structure works out great for people, and many clients, in my experience, have appreciated a flat fee arrangement because they have certainty. They know exactly what they're getting and how much it's going to cost. And that's what I find most people are concerned about. They're concerned about the unknown, the surprises, and how much will this cost. And when you have a fee amount that's known, many times that's comforting. So those are the three different common ways that probate attorneys in the state of Florida set their fees. They can either set it pursuant to a statutory mechanism, which gets paid at the end of the case, or an hourly rate, which generally gets paid per month as invoices are issued or billed against some sort of initial retainer amount, or a flat fee structure, which may be an upfront payment of the full amount, or some sort of structure where certain amounts are paid up front, and then after another period, the second payment is made. But most flat fees I know of are upfront payments. So those are the three different types, and it really just depends on what works best financially for your family. You might benefit from a statutory fee at the back end because you just don't really have the funds to pay an attorney up front. So you're willing to pay at a rate that may end up being slightly higher, simply because the attorney had to wait for the funds to the end when was able to get paid through the probate assets, through the estate's assets. So those are the different mechanisms. I encourage you, if you have questions or concerns, to reach out to probate attorneys and just ask them. Many attorneys, they have no problems discussing their fee structure and explaining it to prospective clients. I hope that this content has been helpful to you. If so, feel free to like and share with others that'll benefit from it. Thank you.